Hey everybody, it takes I think 2 days for me to completely forget how to do every bit of this. Just 5 seconds ago I remembered to turn on the microphone, so I don't know what it's going to take for me to learn this. Hey, got Donald Westerdale, got Emily Smiles, Linus V, LD Henderson, got Fozzie in the house. Fozzie was first too. How about that, Fozzie? Got Sevo Girl, hey Sevo Girl, and Roll on G. She's fighting for first with Fozzie. So, and then Fozzie's cat is coming in at a close second, and Hawaii Breeze at a third. How about that? We got a whole pile of people in here. Jen Hardy show. Hey Jen, how are you? You did a great last night with that young lady singing music. If y'all get a chance, go over and check that out. She's gonna be big, and we're gonna be able to say we heard her first. Well, we didn't hear her first, but we heard her before she got as big as she's going to get. She's got a lot of potential and a lot of future to her. Hey Amanda Panda, how are you doing? Hopefully you didn't get timed out today. Hey Tokyo, how are you? Or good morning, I guess, for there. I don't know. I can't begin to tell you what time it is there. So let's jump into a Judge Simpson DUI plea, and we'll see.
To Erica Julian, appearing on behalf of Holly Brown. Holly, state your name.
Holly Brown.
Okay. We've seen her bond violation report.
Yes, Your Honor. And and she provided a letter to the court. I'm not sure if you were. I have another copy, Judge.
Is that with?
I had provided it to your staff with the file as it was going back, but I'm not sure whether.
Yeah.
Hold on. Oh my God.
Oh, there.
Yes, Frank. Yes, Your Honor. So I'm not sure. We do have a plea agreement in this case, and the way that we came to the plea agreement, discussed at the time that it would be an appropriate resolution based on the factual and legal issues of this case. I know that separately there's a bond violation for us to address with the court today. I wasn't sure in which order the court would be willing to hear them.
To do what?
To either take a plea or to address a bond violation.
Well, I'm a bit reluctant at this point to take the plea because of the bond violation. And also, I will say that, I mean, what should happen here, quite frankly, is you should be remanded because we've been through this. So I read your letter. Tell me why I shouldn't do that with you.
Your Honor, I feel absolutely horrible. I sat right here and I cried when you allowed me to be released and gave me another opportunity upon. And I know that I violated that, and I am owning that, but I did not do anything. I didn't get behind a wheel. I didn't do anything to hurt anyone or myself or any property.
Well, it does hurt yourself.
And exactly, it did, and it does hurt me. But I physically or to anyone or anything, I just want to say that it was a nonviolent act, and I know it was wrong. And right now, I am building from ground zero back in my life, and I am really making strides. Although this violation does not indicate that. 87 out of the 88 last days that I have not had dropped to drink.
What happened? What happened that day? I mean, what happened?
Can I just help facilitate just for a moment, Judge? We had a really long talk about this yesterday, and I was very blunt with Ms. Brown. And just from my initial perspective, and then if she wants to explain further, when she was in custody for 2 weeks and her La Casa advocate was here, we never did get to the bottom of this other thing. And I think we probably would have not worried about it a whole lot, but for the fact that you stepped down from a scram to a sober link, and then she had a positive blow on Tuesday. So when she was released, her La Casa advocate was here in the courtroom and, did continue to assist her. But by that time, they had given away her bed. And that is common and that happens. She went to stay, and she explained all that in her letter, what she did subsequent to that. She's been trying to get back into La Casa. I met with her and her La Casa advocate yesterday. They're anticipating that a bed will be open anytime. And she's been staying in a motel. But what that has to do with it is, honestly, she was doing so well in this entirely structured setting. And when she was released, she was unable to return to that same structured setting. And I think it fell apart on her. And I understand everything that Your Honor had said to her previously. If I could, I don't think she even knows that I know the steps. I think she's, based on yesterday, this is a huge step one issue. Meaning first step of the program, admitting that she's powerless over alcohol and that her life has become unmanageable. This is one of the instances that often folks point to and say, see how unmanageable that made your life become. And I know she is grappling with her, she wants to be sober so badly. She doesn't want to be this person or someone who walks into a liquor store and buys alcohol because that's a go-to. It's been her go-to for 25 years, and she's tried very hard to put it down. And this is me coming to Miss Brown, accepting her cases on appointment, not knowing anything about her, and initially probably having the same view as everybody else. But getting to know her, I understand that she is trying so hard to keep it together, and where it may seem simple, to just simply not consume the alcohol. I know that she struggles every day with all of her past trauma, everything that's happened, everything going on presently. And it is hard for her to keep it together when she is not in a structured environment. And I really don't mean the jail, because I understand that's the next step for her. But she's within just inches of being able to come back into La Casa in that structured environment. And she went to meetings the last couple of days. She went to a meeting yesterday. She was not able to make it today. That's just due to a number of circumstances outside her control. But she is continuing to go to meetings every day. So that's my 2 cents for Miss Brown.
Anything you want to add?
Your Honor, I feel that being in an environment where I'm supported and structured, as opposed to being locked away for something that I'm not a threat to society for, that I will make much.
Hold on. Ms. Brown, but you are.
I hear you. I do. And I'm sorry.
Because, when you say you're not a threat, you're drinking, you can't control it, right? And like you said, I mean, this time you didn't get behind the wheel, but what if you do? And at least 3 times before, 2 times before, maybe a third, you did.
Right now, I am understanding. I'm desperate to be in a better place than I'm at. And the way to obtain that is not by being locked in a jail, but by being in a supportive environment with therapy and with support through AA members and therapists and counselors and advocates, and being surrounded by people who are like-minded in the desire to stay sober and to better their lives. And that's where I am. I don't want anything worse for my life, but I don't think I'm going to be able to start building that sitting down there, over there, where down that way. And I honestly, I mean, the days that I have put in and the time and the work that I have put in, I think does show that the mistake that I made was huge. And I do not deny that, and I'm not minimizing it, but it's just a setback for me. It's not anything that's going to be productive. It's just going to just punish me for something I'm already kicking myself for, Your Honor. That's all. May I add, as far as driving, I do not have access to a car, and this last offense that we're initially here for, the Secretary of State did take my license at that point for 2 years, and that was a year and a half ago. I have had absolutely no, I've not been behind the wheel, and I have not had any, I've had proof of that by not pulled over or having anything. I was not pulled over because I wasn't behind the wheel, but I also wasn't, there's been no traffic violations for me since then. And that was before I knew of the charges that were brought to me. So I just wanted to add that. I do not have intentions of getting behind the wheel until I am legal to do so.
All right. Here's what I'm going to do. I'm going to switch you back to a scram tether. I'm not going to take your plea. I am going to adjourn this out to the 19th of 1 month with the admonition to you that you better hope it doesn't malfunction or anything along those lines. I'm not going to be listening to any of that. All right. If there's any indication that you're drinking, what the court's going to do is we're going to come get you. All right. And I'm not going to, Miss Julian knows me, and I'm not going to hear a whole lot more at all from you.
Understood. So at this point,
So I'll adjourn it to the 19th, 9 a.m. or your Zoom invite indicate defendant is to report to community corrections before you leave here today, and you're to be placed on a scram teller.
okay.
I think the judge just saved her life and gave it back to her. She was a goner for good. She was going to end up in jail, but he gave her a scram unit, and that was awfully nice of him. Hey, Nan, good to see you here. You said you missed me the last couple nights. I missed you. Work got the best of me, and sometimes you got to pay the bills before you get to play on YouTube. And so I had to get some work done. Amanda Panda talking about not believing that lady. Yeah, it makes sense. It makes sense not to believe her. I don't think she believes her. She does what she does. Got a notice this morning of a news story about Judge King, and it kind of bothered me thinking about stuff with Judge King. It absolutely, Brian, girl, the judge sounded so sad on that. But this news story I read this morning, I put it up on my Discord, was the comments in the chat on Judge King's live stream is starting to come to bite him. The judge interacting with people is starting to, people are starting to dig through all the live streams and starting to pick out every little word to go against the judge. We've all got judges we support. We've all got judges we like, and we all end up in their chats. Be careful with what you say. Something simple is going to get one of these judges caught up, and these judges are out there doing their best, and they don't need to get caught up in this drama. They don't need to get caught up in that world, and newspapers don't know how to retract bad information. They'll give out bad information and then just go on about their day. So be careful what you put in the comments, and understand that it can get the wrong people caught up in a mess. So we're going to go over to Judge Boyd as a Fozzie request for Judge Boyd. There we go.
All right. Court is calling 2023 CR 7760, State of Texas versus Destiny A. Valades. Can I have parties announced for the record for the state? Defense.
Matthew Brown, Your Honor.
And are you Miss Destiny Valades?
Yes, sir.
All right. You entered a plea on August 12th, 2024, no contest. According to the plea bargain agreement, punishments be assessed at 2 years in the state jail facility. The state is silent on your recommendation. The state took into consideration 3 cause numbers. Both parties agreed to waive the PSI and just proceed on the TAP evaluation. Have both parties had a chance to review the TAP evaluation, state?
Yes.
Defense?
Yes, Your Honor.
Any objection to the TAP evaluation, state? Defense?
No, Your Honor.
All right. State is silent. Defense, do you have any witnesses?
We do not, Judge, just argument, and if you would like to inquire of the defendant.
All right, the court will hear argument.
So, Judge, having looked back at her criminal history, which is one of the things that you ordered 2 weeks ago when we were here,
Yes.
there is some history, and we can't deny that. But if you go back and look at it, it's the most recent cases outside of the current ones were from 2016, and those are simple failed ID cases.
Okay.
There are no felony convictions for Ms. Valades. There's a couple of items from 2013, 2011, 2010. So it's pretty old things, and it's all misdemeanors. We think that she would benefit from some structure, which I believe probation could provide her. She does have children that her mother is taking care of. Mother, she informs me, has told her that she could live with her. However, she's got to find a job before that happens. So Ms. Valades has reached out to Haven for Hope and discussed with them the potential of living there should the court allow her to be placed on probation. And also we'd point out with the TAP that there's no drug and alcohol criteria for abuse or dependence, and that substance abuse is not, that treatment's not recommended at this time. So we would ask, based on those factors, that the court would grant the application for probation in this case.
All right. Anything you wish to say?
I just want to get a chance.
All right, you're whispering.
I just want to get a chance to help my mom, my kids, and be able to get a chance to get a job.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Destiny and Valades.
All right, so you say you want to help your mom with your children? How many children do you have? What are their ages?
21, 12, 10, and 9. And I'm also her grandma.
Wait, 21, 12, 10?
And 9.
And I'm assuming you're the grandmother from the 21-year-old?
3 kids.
Okay, you're whispering.
She has 3 kids.
So she has 3 children. What are their ages?
5, 2, and 1.
All right, so maybe she was 20 with the 1-year-old. And then the 2-year-old, 19. And then we have a 5-year-old. Why is she having a child at that age? Where were you?
My mom actually adopted my kids.
All right, so why did your mom have to adopt your children?
Back in, let's say 2012, I was going through some things with their father. Mental physical abuse with him. He's no longer a part of my life.
All right, so anyway, if your mother adopted your children, that means there probably was a CPS case, correct?
Yes.
All right, so that means that you didn't do your CPS plan.
I did my CPS plan. My mom talked to me that it was best to do the adoption. She pushed for the adoption. If you were to look into my CPS, I was not terminated my rights. My mom asked me if I would sign.
No, your rights have to be terminated in order for your children to be adopted. There can be no adoption without termination of parental rights. And I know CPS normally does not terminate parents' rights because their spouse or their partner is abusive. Where the termination comes in is when you're doing everything that you're supposed to do, and they tell you that you can no longer be with the abusive spouse. And usually people go back to the spouse. You're smiling when I say that. So what happened? All right. So why are you being dishonest with the court and making it seem as though, oh, they didn't terminate my rights. I did everything and I wanted my mom to have my children, when in reality, no, in reality, they gave you a choice. You can go to jury trial. A jury will make a decision to terminate your rights or not, or either you can have your rights terminated and then someone else will adopt. And so what ended up happening is you chose your man over your children. That's what happened. So why are you pretending that you need to help your mother with your children when your rights have been terminated? She's the parent, not you. You are no longer their parent. You're their biological parent, but legally you're not their parent. And why are you stealing other people's identifying information? All right. Is there anything else?
No, Your Honor.
All right, this is what the court is going to do. The court previously stated the court had found you guilty. The court is going to sentence you to 2 years in the state jail facility. Give you credit for any time served. There's a $1,500 fine. Time and money will not run concurrent. The court previously, according to your plea bargain agreement, is taking in consideration the following JN numbers: 6788324, 6788325, 6788326. There's to be restitution and no contact with Christopher Geyer, Geira. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Stop using your children. Stop using your children to get out of criminal cases that are of your own making. You knew that legally you were not the parents of these children. You knew that your mother was raising them. You're not raising them at all. And if you truly love your children, which I hope you do, the choices that you've made up till now shows that you put yourself above your children and put a man above your children. That's why your mother has them. But do one thing in your life for them. And this is what you should do. Don't go stay with your mom because you're not having your life in order. You have no plans to get your life in order. You're just there to continue this cycle of using people. You need to stop. Go to the state jail facility. Get your life in order. If you have a drug issue, get the drug issue in order. Don't come knocking on the door trying to be a parent. Don't go knocking on the door being a bad influence to your grandchildren. Do you understand? All right, good luck to you. Thank you, counsel. All right.
Did she just say don't?
Court is calling.
Did she just say don't go being a bad influence to your grandchildren? I didn't catch that the first round or two. So she's old enough to be a grandmother, I guess. Okay, well, that's that. Never choose a guy over your kid. I will never choose a guy over my kid. I wish everybody would do the same as me. See a girl saying her mom and dad chose her new spouse. She can never do that. No, not at all. Not at all. Hey, Steve, I saw you sneak in there. Never do that. Never do that. Amanda Panda, go watch that interview with Jen Hardy and Judge Boyd. It makes a lot more sense, than what we're saying on there. But she's got her fashion, she's got her style. Each judge has their own different way of doing things. So back to the Judge King story. I saw that where Fozzie said that the moderator got run out of there. I don't know much about that moderator, but yeah, it's a dangerous world that they're in, and they've got to play by the rules. And so, but also I saw where that moderator had made a few comments that gave them easy ammunition to make it look bad. So maybe some training, if nothing else. So let's see if we can get on this one here. It's another sentencing.
2020 CR 4853 and 2022 CR 0067A. State of Texas versus Donald Joe Gilliland. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Jose Rocha, Your Honor.
Are you Mr. Gilliland?
Yes, Your Honor.
And each of the cause numbers, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
And cause number 2022 CR 0067A, are you the same Donald Joe Gilliland Jr.? who was placed on probation for fraudulent use or possession of identifying information, 50 or more items on December 16th, 2022 for a term of 6 years? And are you the same Donald Joe Gilliland Jr., who was placed on community supervision in 2020 CR 4853 for the offense of fraudulent use or possessing identifying information 10 or more elderly on December 16th, 2022 for a term of 6 years? Is that you?
Yes, Your Honor.
All right, state.
In both cases, violated condition number 4. In Bexar County, Texas, the defendant, Donald Joe Gilliland Jr., did then and there fail to report to the supervision officer as directed for the months of January and February of 2023 in violation of condition number 4.
How do you plead to that in each motion? True or not true?
True.
State.
Your Honor, state waives all other violations.
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4 and cause number 2022 CR 0067A? The court could find it true, grant the motion, and sentence you to 6 years in prison.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? Court is finding violation of condition number 4 true. Did you understand by pleading true to violation of condition number 4 and cause number 2020 CR 4853? The court could find it true, grant the motion, and sentence you up to 6 years in prison. Knowing that, do you still wish to plead true to violation of condition number 4 and that cause number?
Yes, Your Honor.
Court will find violation of condition number true and that cause number as well. Is there an agreement?
Yes, Your Honor, it's to deny the motion, but to alter and amend conditions for a 60-day jail sanction, bi-weekly drug testing and after that for 90 days, random thereafter. You must verify employment and residency within 30 days of release and continue with field visits 2 times per month as originally ordered.
And that's our understanding, Your Honor.
All right, why should I follow that agreement? He's not reporting. Why are you not reporting? Can you raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
You can lower your hand. State your name for the record.
Donald Gilliland Jr.
Why are you not reporting?
I had a problem and I was told that. Your Honor, he had a domestic problem with who he was living with that kept him from being able to get all of the documentations and being able to keep up with.
No, he
all of
just
the
needed to go to
requirements.
probation and report.
And he understands that now, Your Honor, and that's why he's asking for this court to allow him to be able to prove to this court that he'll be able to follow all these amended conditions.
I mean, the thing is, though, he's proven that he can't. So I don't understand why I should follow conditions for someone who didn't do the basic thing, which was report. And I know I tell everybody in this court, if there's an issue with communication with your probation officer, we are always here to maybe help smooth the roads to communication. But he didn't report for 2 months. So what was he doing?
Your Honor, he was homeless. Going from one place to another, Your Honor.
That still doesn't explain why he's not reporting. And the fact that his charges are what they are, that's not good to not be reporting. So basically, he has done nothing. Has he done anything on probation other than not report?
No, Your Honor.
So he's done nothing. So we're back to, why should I follow this agreement?
Because I'm relying on myself to do what I need to do instead of others. I was relying on my girlfriend, and she told me basically that the work that wasn't on there, that if I showed up, they'd arrest me, and so I didn't
That makes
show
no
up.
sense. You were supposed to report.
And I was going to break up with my.
No, you were supposed to report in January and you did not report. So what do you mean about this nonsense that if you reported in January, you would be arrested? I don't understand.
That's what I was told. That's what I was told. I mean, I should have followed up myself, but I didn't with my anxiety and my VA. I was trying to follow up with that at the same time. And I didn't. Now I'm going to take responsibility for myself and get to stay on my meds and get the VA done and do everything.
I'm not going to follow your agreement. I mean, you had your chance. You were here, you were supposed to report and you did not. I mean, that's the easiest thing to do. You haven't done anything.
I was told by that, she said the police showed up several times and I was supposed to report and they were gonna do a walkthrough, so I was waiting for them to come up with the money to do a walkthrough with my girlfriend. And I listened to her. I didn't know anything about the systems and she did, so I trusted her. And now I need to trust myself and do it myself.
Well, I mean, you knew enough about the system to have 50 plus items that are not yours. All right, the court is going to grant the motion. The court is going to revoke you. The court is going to sentence you to the minimum, which is 5 years, TDC. Give you credit for any time served. And I'm going to sentence you to 5 years in each case. The cause numbers will run concurrent with each other. All right, that will be the court sentence in each cause number. In each cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
You need to speak louder.
Yes.
So she can-
All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you.
All right, so last night Tokyo had a good stream going, and I was talking with a lady, and we had mentioned Debbie Davis, and she was asking about a Debbie Davis case, and I had mentioned the one where she had gotten in trouble with the district attorney, and she had asked if that was the one where she had caught the abuser and the victim in the same apartment. And I was like, no, Debbie Davis has plenty of hits, and Fozzie, you brought up a good one there. That I know where there's free lodging. I can't wait to see her sharp-witted in this in the district attorney's office. I think that's going to be a good thing for that county. Certainly it'll give Judge Middleton a good retirement plan out, because they seem to work well together. So at least they'll bring some common sense into that. Back to the Judge King thing, that the moderator Rachel, I certainly don't mean to knock her. I didn't spend any time in there. I did see that. I think it's a detective Rachel something, but I hadn't paid a lot of attention to it. I was trying to understand the process more than paying attention to the conversation. But newspapers will lie and tell anything they can to get people to read. And so I believe that they just looked for anything that they could to make that story, more. It's salacious, the word. I don't know what the word is, but just to make that story, more than what it is. In the end, it was Judge King trying to get a point across, trying to do his job, trying to leave an impact on some kids, and it made out for a big story. But Deborah Davis is definitely amazing. She's gonna do really good for it. All right, we're gonna go on to the next one. This guy here, I think he got, I think it was at least 5 years he got for not reporting. So Judge Boyd was just done with him. So we're gonna go to Judge Washington.
That day, excuse me? Oh, sorry, okay.
The court will recall the matter of the state of Michigan versus Crystal Gellermino, case number 23S00511.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Crystal Gellermino.
Ms. Gellermino, please state your name.
Crystal Lorraine Gellermino.
Thank you.
You're welcome.
All right, Ms. White, you had a chance to talk to your client?
I have, Your Honor. As to the bond violations, she's going to admit to the bond violations. And as to the pretrial, I believe this is not a pretrial, but she understands that she will meet with probation, and we are asking as to bond that she be released to an inpatient facility as soon as a bed becomes available.
Thank you. Ms. Gellermino, it's my understanding that you're going to plead guilty to the bond violation. I'm going to include the bond through the date of July 9th, at least. She was not arraigned on this matter until August 12th. but I believe that she just stopped testing at some point. Ms. Gellermino,
Yes, Your Honor.
it's my understanding you're going to be pleading guilty to the bond violation. Is that correct?
I am.
You're going to
Sorry.
waive your right to have the hearing in this matter and plead guilty?
Yes, Your Honor.
All right.
Might I ask for a little bit more transparency? I was told in my bond matter that I would speak to probation, and then I would wait for a bed to open in an inpatient. And I'm
Ms.
wondering.
Gellermino, we're going to get to that in a moment, okay?
Okay.
So you pled guilty on this case on May 31st. And then it looks like on June 12th, you missed a scheduled test time between 6 a.m. and 9 a.m. You didn't test until 9:16. Is that correct?
Yes.
Then on June 15th, just 3 days later, you tested at 8:40 a.m. as scheduled, but was positive for a BAC of 0.070. Is that correct?
Yes.
You retested on 3 separate occasions, still testing positive. Lowest number is 0.066, correct?
Yes.
Then you started to miss the retest at 9:50, 10:20, and 10:50. Is that correct?
Yes.
On June 15th, June 16th, June 17th, you missed test those dates, correct?
Yes.
And then you stopped testing, period, and hadn't tested since June 22nd for a total of 34 missed tests, correct?
I believe all that's true. Yes.
Yeah. So you just absconded from supervision in its entirety, correct?
Yes.
All right. I find that there is a factual basis for the bond violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Satisfied, Your Honor.
Thank you. Now, what were you saying, ma'am? You wanted to talk to me about being released to treatment?
Yes, I was wondering if it could be a little bit more transparent where I'm to serve this out and I could make up my mind. I didn't realize that Dawn Farms was on the table, and if Dawn Farms is.
You're not serving a sentence. Well, you have pled guilty, but you haven't been interviewed yet. So you're not serving a sentence just yet. You can talk to the probation department about all of that, and maybe someone can work it out for you if you'd rather just sit there.
Okay.
Okay.
Thank you.
And then when you come back the next time, maybe it won't just be a misdemeanor, it'll be a felony, and then you can do some time in prison.
Well, if I stay away from the courts and maybe go to an Ann Arbor court when I have something, maybe they can help me.
Yeah, maybe so. That's your choice.
Okay. Miss McDuffie dictates everything, so.
Ms. McDuffie, since she keeps calling you out, do you want to respond to anything today?
She done told you that she was gonna lie in your court and you got the
Ms.
message.
Ms. Gellermino, let's stop now, please.
I would like to respond, Your Honor. Thank you for that.
You may.
I'll keep her tied up in court for years.
Ms. Gellermino.
Oh, I'm not on mute, excuse me.
You know you're not on mute, ma'am. Don't play games with me. Because you're going to find yourself in contempt next, okay?
Yes, ma'am.
Ms. McDuffie?
So the reason I keep referring to a sentencing memo in this case, I think is probably obvious by now. I don't think I have yet had a defendant show up to court with my name in their mouth about 6 or 7 times before I've said a word. In this case, my concerns that I've already articulated about Ms. Gellermino is that despite her somewhat willingness to admit to the fact that she has a serious, extremely serious alcohol substance abuse problem, that she is also very manipulative and in denial on some level, which is that everybody else is the problem. And down to, I do want to make the record clear since she put all this on there about it. Ms. Gilliland previously had an offer. She had a couple of different options for an offer. She wanted to dictate the terms for all of those options and more. What those offers did not include another stint at the 15 District Court's Mental Health Treatment Court. I cannot really these courts are confidential. I can't really get into detail about what I happen to know about Ms. Gilliland's journey or experience in that court. But what I do know is that this court's recovery court is focused on substance abuse, and we are aware of mental health concerns, but there is a different approach and to the supervision and accountability that I know that this court takes with the substance abuse issues that we handle. And I think that that was necessary and would have been very helpful for her. Ms. Gilliland has refused that level of accountability, and she wants to go have it the way that she had it in the mental health treatment court, where those issues, quite frankly, were not addressed, as we can see. Ms. Gilliland has blamed everybody else, including the fact that she has to witness and be around other people's crack pipes in the city of Ypsilanti for her substance abuse problem, for her consumption of alcohol, for her being in this situation because of her behavior when she is under the influence, down to dictating where exactly she wants to go. I have never, as the court said, suggested once that if you fail at something, we don't try it again. It's exactly the opposite. We have people in our courts who have tried recovery programs, I think upwards of 30 times. And finally, they made the decision to be honest with themselves about getting the help that they needed, about to stop trying to run their program and to dictate their circumstances, because it clearly hasn't been working so far. I don't know what it's going to take for Ms. Gilliland to get there, or to understand that I'm not her enemy, to understand how much her behavior is damaging herself and her family. But that's what I am here to see about, is that we do everything we can to ensure that happens. That solution is not one that she can create for herself, because she's not in the position to control her own recovery when she's the one that needs it. With that being said, Ms. Gilliland can insist that she wants nothing to do with this court's recovery court. We can't make her do that, but she is on probation, or whatever the sentence that this court plans to impose will be. And so I am still committed to ensuring that we do everything we can to get her to the place where she can finally start to engage in her recovery and what she truly needs for it. Ms. Gilliland was also in custody, or at least she was at one point, because she had a new offense committed while on bond for this case. I looked into that. I don't think that it's that case is, I think the warrant was authorized, but I don't know if it's an open case that's out pending yet again too. So I don't have any issue with Ms. Gilliland being released to a treatment program. As you said, it needs to be the longest term I think that we can get. I would request confinement to that facility or that location. And I don't know to what extent an assessment is going to yield us some useful information in terms of where she needs to go and what she needs to do. I don't think that we're able to provide information to the assessors, because I don't think it works that way. So I'll turn over everything that I can to the court based on what I know that may be helpful for supplementing the decisions that the court needs to make with her moving forward. But Ms. Gilliland knows good and well that I am not running this show. I am not dictating what happens in this courtroom, but I am here to tell the truth, and I'll continue to do it for her best interest.
Well, I don't believe that.
Ms. Gelomino.
Oh, all right. We're here today for a bond violation. She's pled to the bond violation. We've accepted that. She's made her statements regarding how she feels about this court, about the prosecutor, about the recovery here, about Ypsilanti, and we are fully understanding that. And if she chooses to sit there, she can do that. I will modify the bond to have her released to a long-term inpatient program after she is interviewed by the probation department. And then if she doesn't want to go, she doesn't have to go. Obviously, that's up to her. And we'll see how things go in the future.
Thank you.
We'll see her back here on September the 23rd for sentencing at 10 o'clock p.m. a.m. At 10 o'clock a.m. Bond is continued otherwise.
Yeah, I love Rachel McDuffie when she gets mad, she gets worked up. She certainly has the right words to say. I don't know a lot about her. It seems like I'd seen her on some news shows like Fox News or some other news channels. Has she been on court TV? Someone put in the comments if she'd been on court TV or something. But she's certainly, I've seen her somewhere in the news. And I'd first seen her in the court thing, and then I saw her on the news and kind of put it together. But what channel has she been on the news? Somebody knows out there. All right, I'm gonna throw up an old one, and that'll make for a short night tonight. I gotta get back to work, but I didn't want to not do one tonight. So this one's
Ian Michael Scott Harvey.
Yes, Your Honor.
Okay, on for pretrial and review. 22L001727, 20L002123. How are we proceeding today, folks?
Your Honor, this one, the pretrial matter ending in 1727, that's going to be the city's motion to dismiss with prejudice. And then as far as the order to review revocation, the city will be asking for revocation today. And if the defense objects to that, then I'd just like to be heard on conditions of release. But otherwise, we're prepared to go forward with revocation today.
Okay, we're gonna go in order. So the case ending in 27, any objection to this dismissal on that one from defense?
No, Your Honor.
All right, so I'll enter the dismissal with prejudice on that one. And that case will go away, never to return, sir. And so that was a 2022 theft case. All right, turning to the other matter. Which is the review matter, which was a 2020, also a theft case, guilty finding, order on revocation. Is defense prepared to go forward today, or would you like more time?
We can move forward, Your Honor.
Okay. All right, so would you like to hear the city's recommendation? And then, okay, so I'm gonna hear from the city, just your recommendation, unless you wanted to have council highlight their highlights first.
Your Honor, it's a fairly straightforward revocation. We're asking for 21 days in custody with 1 day for credit for time served. This matter would then close after that serves the jail time. And the reason for this revocation is in the time period in which Mr. Harvey was on probation between March 30th, 2022 and March 20th, 2024, he was found guilty on 3 different charges of theft 3. And I've noted the jurisdiction and the date in that revocation. And so because of those guilty findings during the probation, we're requesting that 21 days and then to close, Your Honor.
Okay, I'll hear from defense.
And Your Honor, just some procedural background. So what the city's asking to revoke jail time on is a 2020 charge for which Mr. Harvey pled guilty at arraignment. It looks like he pled guilty at arraignment back in March of 2022. Your Honor, I'm asking the court to give him 2 days with credit for 2 days served. I'm looking, this is, let's see. I'm only seeing, maybe I'm mistaken, two new convictions, but that's, I guess, neither here nor there. This was a theft charge of food from Safeway. My client is homeless. He was cooperative during his arrest. It's unfortunate, right? I think he would be really well served by community resources and community court if that was an option for him. I'd love to get him in that, but because this is a review case, there's not that option. I don't know what benefit putting him in jail for 3 more weeks would do, but he's homeless and he was taking food from Safeway. Stealing is obviously wrong.
He does have those misdemeanor theft convictions and a number of warrants out for him. He doesn't have any transportation. He knows about the warrants and knows he needs to take care of them, but I do think that he really needs some help.
All right, thank you. And sir, was there anything other than what your attorney told me that you wanted the court to know, or did it do an adequate job of representing your interest?
She covered everything pretty good, Your Honor.
Okay. Well, I understand the city's position. I don't think that's a unreasonable request, frankly, with the amount of, with the convictions and the actions taken, but I also understand defense's position that you're not served by sitting in jail. You'd be served better by having an opportunity to take advantage of some community resources and get yourself hooked up possibly with long-term resources that could bring you some benefit. And so I understand both sides of the coin here. I do feel that some consequence is merited. And while I think the city's recommendation is fair, I'm also compassionate towards your position. And so I'm going to cut it in half to 10 days and give you credit for a day served. You are going to spend some time in custody, but then this file is going to close. And I'm hopeful that, well, I'm mostly hopeful that maybe you choose a different path, since it looks like there haven't been charges since October of 2023. And if nothing else, if you do continue on this path, I hope you are take advantage of the resource, either because I see you have pending charges in Bonnie Lake, and I know they have a community court, and Puyallup has a community court. And so perhaps you could, just knowing that those two jurisdictions have that, if you reached out to those jurisdictions and your interest in community court, both of them take very seriously participation and getting you hooked up with resources over making you spend time in jail. I share that with you, not just to hear my voice, my own voice, but to tell you that there are courts. Those are two that you have warrants in. I'm not as familiar with some of the others that you have warrants, but I know specifically those two courts that I am in quite often, that they have robust community court advocacy to tell you that if you go in there, they're going to be interested in helping you through that program. And so that hopefully you could advocate for yourself to at least get into it. And then that would maybe help you in both courts because they're not far apart and they may be respect each other's process as far as you getting into the community court. Okay.
Okay.
So I'm just sharing that with you as information because I practice out there and my court is right next to those courts. So that being said, I'm going to impose the 10, give you credit for 1 day served, close your file.
Should be 2 days, Your Honor. I'm sorry, I didn't mean to interrupt you. He has a day from a previous booking that was post-conviction. It was booked and released.
Okay. Any argument with that from the city?
No, Your Honor.
Okay. Give you credit for 2 days with good time. That should be shortened up a bit as well. That's between you and the jail. And then I would encourage you to attempt to get involved with those courts where you have warrants. Get, if nothing else, the community resources through those courts because they have officers and people appointed to specifically funded by the state to help you. Okay. I know that doesn't sound right because you're thinking the court system isn't supposed to help me, but that is actually what is going on in this state is a lot of courts have people specially appointed to help people have a better life. So, all right. Can't order you to do it, but boy, would I encourage you. Okay. All right. Sign that order you be given a copy, and then I wish you good luck, sir.
Thank you.
So she's talking about she can't force them to do the right thing, but the people there to help. I guess the concern that I have is how much of a person do you have to help? Anyone who works in a court system knows that, you can hire somebody to be a, community coordinator or do something. But if you've got, 50,000, 100,000 clients, there's really not much you can do. This guy got arrested for stealing from a local grocery store. I feel bad for him, but hell, imagine being a store owner. Imagine, trying to keep inventory and people are just coming in and stealing everything they want. I don't know what the answer is. I know it's certainly not good to keep them in jail, but there needs to be some sort of system in it. I see I see Victoria has Michael on off his leash just for a little bit, so that's good. Nan, you said seeing this as educational, just in case you moving with daughter. Well, if she lives up there, hopefully you won't need too much education of the court system up there. Hopefully you'll go up there and play nice. And so, absolutely, Kay, he was stealing food and homeless, but in jail he sleeps inside, provided meals. No, absolutely, but is his mental health actually treated? Is anything actually done other than us warehousing him? I don't know the answer, but I've seen a lot of people go to jail and get right back out, and not have any resources. They're just let right back out on the street. So, but anyways, Bill, Victoria's it's not a leash, it's a yoke of oppression. Absolutely, right. But thank you, Linus. Today in Judge Fleischer's court, people got rowdy. Think about the Judge King thing, and whenever you make your comments, I know sometimes there's some little inside jokes, but just be thinking about all the drama going on with Judge King right now, and you don't want it to spread. If it becomes a national story, national attention starts to bring, and we don't want to mess up any opportunities we have to participate in the process. So make sure to this crowd here. I'm looking at all the names here. This crowd is certainly not the problem, but just make sure that if someone says something silly and wants to make an argument, just don't participate in it. Get the heck out of it and let the great moderators over there do their job. Kathy runs a good ship over there. So, and as long as she can keep Victoria out of the after there, I think prisons are better equipped for mental health recovery than jails. Yeah, Tokyo. I'd much rather be in a jail than a prison. I think I'll take a jail any day. But y'all have a good night, and remember in the comment sections to be good. I don't, in the end, on my comment sections, I just want people to be nice to each other. There's no secret words or anything that I really care about like other ones do, but I have different problems than everyone else. So Victoria Sanfoz is the only problem here. I'll leave it on that one because no one believes that, Victoria. Everyone knows who the problem is. Y'all have a good night.